We kick off this hour in Idaho with the latest news on the Doomsday couple, Chad and Lori Daybell. These two were reunited in the courtroom for a really important hearing ahead of their April trial. Cameras were not allowed inside the courtroom, or else, believe you me, we would have been there. But we know that one of the biggest issues taken up was this request by Lori's attorneys, hear me, just Lori's attorneys, for her and Chad to be able to meet up in person and also speak on the phone, to have what the attorneys call strategy sessions. Now, state prosecutors voiced their objections to those kinds of meetings and discussions, saying that these defendants do not have an inherent legal right to have direct communication with one another. Also saying that any communication between the two of them and their attorneys together could turn the attorneys or Chad and Lori into potential case witnesses. Now, the judge heard the arguments surrounding this request and made his ruling. Take a look.
The concerns raised that the court really shares are potentially the defendants inadvertently waiving privilege, because privilege only applies between lawyers and clients, and once you get other people there in the room and start talking about facts of the case, if that comes up, what they may believe is privileged may not be privileged. I'm concerned that attorneys present in these meetings, depending on who says what, could inadvertently make themselves witnesses in the case against the other party, and could result in themselves inadvertently being required to be disqualified from the case. I'm particularly concerned with the suggestion that, given the heightened security around these defendants based on not their conduct while in custody, but the charges, that the sheriff's office is in charge of their security during the course of these proceedings, and a request that both defendants be put together in a room without security in the room present, which I think would probably violate all the protocols the sheriff would have as it relates to any in custody defendants. That concerns me. And then we go back to this issue. Well, if somebody's in the room observing their law enforcement, they're listening to what's said, it's not privileged. So to me, it's a idea that's full of pitfalls that, in my opinion, would far outweigh any benefit. So as inconvenient as it may be to have to relay messages through counsel, that's the way the law is designed, to protect the rights of the defendants and have these privileges remain. So upon consideration of that, the court is going to deny the motion, and will submit an order to that effect.
All right, let's talk about this some more, shall we? We have a wonderful think tank tonight. Joining me in New York City, former senior homicide prosecutor Bernarda Villalona; in Cleveland, Ohio, criminal defense attorney Ian Friedman; and in Los Angeles, California, criminal defense attorney Lada Uretzian. Wonderful to see you all tonight. Thank you so much for being on Closing Arguments. Okay, let's talk about this ruling, and was it the right one? Ian Friedman, you know I love to pick your brain about rules of criminal procedure and rules of evidence, and we know how the judge came down and said, you all aren't going to meet on this one. Right call or not, and why, please?
It's a safe call, Julie, at this moment, but preparation for trial is unique. It's different every single time. These lawyers may run into the situation where they need to be together for some reason. There may be some obstacle that hinders the defense if they're not. I didn't hear any specificity that was articulated here today, so the judge is kind of making his ruling based upon what was stated. However, if a situation arises where they do need to be together, for part of the defense, if it is in fact a joint defense, I mean, we don't know exactly how they're going to present it. That may have to change. So I hope the judge is not locked in on it. Doesn't sound like he is, because there's other rulings he made we know about, I'm sure we'll discuss, that he's willing to still listen on. And so I think that as long as that opportunity is still there to be heard, and he can kind of adjust it from there, it's okay as of today. But today doesn't necessarily dictate what tomorrow will necessitate.
Yeah, well said, Ian. You said something else I want to expand upon further, and that is whether it's a joint defense. We may have gotten a clue with this hearing and this issue being brought up. Lotta Uretzian, let me go to you on this one, please. With John Pryor, who represents Chad Daybell, not joining in on this motion made by Lori's attorney, essentially saying he also objected, like it has no interest in this meeting and any strategic planning or talking. And so that makes me kind of wonder, oh boy, is he kind of sending up signals that this isn't going to be united together in court, even though they're united in holy matrimony? What do you think, please?
I mean, it's possible. I got that sense too, but I also got the sense that this was about trial preparation for him, and the idea that the judge wouldn't allow them to meet, I thought was not necessarily the right decision in this case. We've all seen and have had many cases that involve co-defendants, and even when there's an order, ordering the co-defendants not to speak to one another, most of the time, if not all the time, judges will allow them to talk to one another and be in each other's presence when their counsel are there. These are seasoned attorneys, and they know all the risks involved. As long as they explain these risks to their clients, they should be allowed to be in the same room discussing the case. And I got the sense, at least from both attorneys, yes, one was more pro than the other, but at least there was some kind of an agreement that these two maybe should be able, I think they all should be on the same page, that they should be able to be in the same room to discuss the case.
Sure.
Whether it's joint defense or not.
I appreciate it, Lotta. Bernarda Villalona, let me please tap into your experience as a prosecutor. We know these prosecutors were jumping up and down to make sure this does not happen. And they had a little victory with the ruling we know thus far from the judge on this. Help us understand why prosecutors would not want Lori and Chad talking to each other and sitting down together prior to trial.
Well, number one, there's no constitutional right for you to have access to your co-defendant. Usually when you have cases with multiple defendants, when they're in custody, you keep them separated. And you keep them separated for a reason. It could be tampering with each other's cases. It can be both of them trying to synchronize some type of plot or plan. It can be for so many reasons. But most importantly, what the judge said is that there is no attorney-client privilege once you bring in another person into the party or the conversation. So this judge is trying to protect the right of each of these defendants, especially if early on there were arguments about a motion to sever. So how is it before early on you wanted separate trials for these defendants, but now you want to unite both defendants, which can change next month or next week? And what are you going to do with the information you learn?
All right, appreciate it, Bernarda. Another big issue that was brought before the court was something also raised by Lori Vallow's attorneys, and that was her eligibility, or ineligibility, I should say, for the death penalty. Her lawyers are saying that prosecutors cannot prove that she participated or orchestrated or had any knowledge of these killings, therefore she's ineligible for it. Take a listen to some more of what they said, and then Lotta, I'm coming to you right after this.
I know the state thinks that I'm making this up, but I didn't make it up. It's in the case law that you either, in order to be death eligible, you have to kill or attempt to kill, or you have to have reckless disregard for human life, and you have to be a major contributor to the crime. We don't believe that they are going to be able to prove that Lori was a major contributor to the crime, and we don't believe they're going to be able to prove that that Lori actually participated in any of these events, or that she even knew about any of these events that were going to happen. She didn't anticipate them happening, and certainly was not a participant. The state has indicated in their response that they will be able to prove beyond a reasonable doubt that Ms. Daybell intended for her victims to die. We look forward to hearing that. The state also indicated that Ms. Daybell participated in the killing of her own children. We look forward to seeing the evidence on that, because we don't believe that either of those statements can be supported by anything. That certainly is new information for the defense.
Mrs. Daybell is not charged with felony murder. She's not charged with the death of her children and Tammy Daybell in furtherance of another felony. She's charged with conspiracy to commit murder. I'm not going to get into the evidence of the case. It suffices to say that a grand jury has found probable cause and that she did commit these crimes. And I certainly understand the defense is not going to come in here and admit that. But there has been a probable cause finding by a grand jury she committed these crimes. The state has complied with the rules laid out to seek the death penalty. Again, there's no case law, nor has any case law been presented that applies these rulings in these felony murder cases to conspiracies to commit murder. The word is intent. That's the issue here. And that's what probable cause has been found by a grand jury to exist, that she intended for her children and Tammy Daybell to die. The state intends to prove that. Absent any precedent that would apply this, the rationale of Edmund and Tyson to these cases, we'd ask this court to deny the motion.
All right, so the judge has taken the issue under advisement. He'll be making his ruling by way of a written decision at some point in the near future. We don't have an expected date on that, but we'll certainly keep everyone posted. Lada Uretzian, I want to tap into your experience doing death penalty cases. One very famous one I know our viewers are aware of. Scott Peterson is one of the people you have represented throughout your career. And tell us who you think is right on this one. Does Lori have a point here that she shouldn't be eligible for potentially the death penalty because of lack of direct involvement, as her attorney says?
It's a very interesting issue that her lawyers have raised. It almost sounded like they were arguing, and they are arguing, that she's not guilty. To me, basically they were arguing the elements and basically saying she had no knowledge and she didn't participate. I don't know if they're arguing that she's an accessory after the fact. I'm not sure, but honestly, to me, it sounded more like an argument that you would make to a jury that they should be acquitting their client versus whether she's eligible for the death penalty or not.
Mm-hmm. Right. No, it does certainly sound like that. And another question, somewhat related, please, Lada, is one thing that jumped out at us here at Court TV was that John Pryor, who represents Chad Daybell, did not file the same kind of motion, saying that his client isn't death penalty eligible. And from what we understand, that's kind of a standard practice. Do you see that as problematic? Why or why not, please?
Interesting that he hasn't filed it. Maybe the defense, and it really does stand out, because it's interesting that Lori's attorneys are raising that argument. You would think that automatically he would be raising the same argument, unless, and I can't even say that, it almost looks like he's a little more involved. There's more evidence than we know of. I thought the involvement was pretty close on both ends, and they're both involved based on the evidence that I've heard until now. So it's a little interesting to me. Maybe they're taking their time, that maybe this is coming up and they just haven't filed it.